Welcome to episode 73 on the Law Report. This is a very quick episode going to deal with ex parte hearing or hearing without notice and injunctions. And I am doing this episode in light of an issue that has been trending on social media for a few weeks involving an ex parte hearing for or an ex parte application for an injunction against media personnel. And someone asked me, how could someone file an application without the other party having knowledge of it, and how can a judge make an order in the absence of the other party? So I decided that I would just deal with the issue very quickly so that I could put the curious minds out there at ease. But before I do, my usual disclaimer: this is not legal advice. Nothing that I say in this episode should be taken as legal advice. For legal advice, please contact an attorney of your choice. Welcome back. An ex parte application or an application without notice is a term which refers to legal proceedings that are conducted without notice to and outside the presence of the other party or parties affected by the proceeding. Typically, ex parte proceedings are permitted only when a party needs urgent relief that cannot wait until the adverse party is informed of the request and given an opportunity to respond. However, in my view, once the order is made, the party in whose favor the order is made has an obligation to solve all the documents, the application, the order, the affidavit, and the grounds on which the application was made upon the other party as soon as practicable. So, what is an injunction? An injunction is a court order which orders a person, it could also be a company, to stop doing something, which is called a prohibitory injunction or a mandatory injunction, which is to stop a party from doing or acting in a certain way. A party who breaches an injunction can be held in contempt of court, which in some instances could lead to imprisonment, or there could be sanctions against property, etc. When can a party seek an injunction? An application for an injunction can be made before or after proceedings have begun. The court can grant an injunction before the start of proceedings where the matter is urgent or if it is necessary in the interest of justice. For example, if it is a matter where funds or property is involved, and there is a real risk that this property or funds could be dissipated or depleted or destroyed before the full hearing. An injunction made before a trial is known as an interlocutory or interim injunction. It can remain in force for a particular period of time. Otherwise, it remains in force until the matter comes to trial or the court makes any further order. When the matter comes to trial, the court will decide whether or not to make a final injunction. Interim injunctions are very commonplace. Now, what are the general principles? The principles applicable to injunctions are: 1. The party applying for an injunction must have a valid underlying claim. The party must be able to show that it has a legal rights which have been or is likely to be undermined by the other party's action, or that the party have behaved or is likely to behave in an unconscionable manner. A substantive cause of action, that is, one capable of founding an action before the court, must exist. 2. An injunction is a discretionary remedy, meaning that it is within the discretion of the court whether to grant the injunction. An injunction is an equitable remedy, which means that the court is not obligated to grant an injunction and will only use its discretion to grant an injunction where it appears to be just and convenient to do so. An injunction is subject to the usual equitable rules. In particular, any delay in applying for an injunction can seriously damage the prospects of obtaining one. The party applying for the injunction must have clean hands, that is, they must have acted properly themselves. And 3, damages must not be an adequate remedy. The court will not grant an injunction if an award of financial compensation would be an adequate remedy. That is, if the party applying for the injunction can be redressed in full simply by an award of damages. Interim injunctions are either obtained on notice, that is, by giving notice to the other party, or without notice. With an unnoticed application, the other side is told that the application for an injunction is being made and when and where it is to be heard. On the other hand, a without notice or an ex parte application is made without the other party having any notice of the application or being present during the hearing. The court may only grant an injunction and such an application if there are good reasons for not giving the respondent any notice. Example, that the matter is so urgent that the applicant does not have time to tell the respondent that he intends to seek an injunction, or where given notice would lead to serious risk of evidence being destroyed or assets being dissipated before the injunction is heard. Applications for an injunction can be ex parte or inter partes, as I have previously explain. To proceed with an ex parte application, it is necessary to show a strong enough case to justify the court proceeding without hearing the other side's case. It is crucial that the party applying for the injunction disclose all relevant facts to the court, including any matters unfavorable to its case. Failure to do so can result in the injunction being set aside and the court ordering the applying party to pay the costs of the other party and damages for any harm the injunction may have caused. If the court grants an ex parte injunction, it will usually fix a date for further hearing with all parties present, and the interim injunction will only last until the date of that hearing. Alternatively, the interim injunction may be expressed to last indefinitely, that is until trial, but with a proviso that the parties subject to the injunction can apply to the court to vary or discharge the undertaking. At any further hearing, the party that is subject to the injunction can argue that the injunction should not have been granted or should be set aside. The court has powers at all times to vary or set aside an injunction and the application of any party. So, what are the procedures that must be followed in obtaining an injunction? When an application is made to the court, it requires a formal application notice supported by an affidavit and evidence supporting the reason for the injunction. The application notice must state what order the applicant is seeking, the reasons why the applicant is seeking the order, if there is a hearing, the date, the time and place of the hearing, and as previously mentioned, an application for an injunction, an interim injunction, must be usually supported by evidence. This will usually be in the form of a witness statement, affidavits, including all material facts of which the court should be aware and attaching any relevant documents. Injunctions are normally argued on the basis of statements or affidavits rather than live witnesses. Now, injunctions are rarely a costly procedure, whether you are the party applying or you are the party defending against the injunction. And although it would depend on the circumstances of the case, factors that will affect the cost will include the urgency of the application, the number of witnesses involved, and whether the application is made ex parte or with notice. So to put the curious minds at rest, an injunction, an application for an injunction without notice is permissible and proper, and there is nothing untoward in granting an injunction in those circumstances once the court have properly assessed the application based on all the information put before it. I hope this has been of some help to the curious minds out there. I thank you for listening. Please like, share, and comment, and I'll see you shortly in another episode.